You know the feeling, right? You're in a high-pressure negotiation, and the contract in front of you feels, well, it feels less like an agreement and more like a trap. But where's the line? When does that intense pressure go from just tough bargaining to something legally unfair? Well, that's exactly what we're going to break down today.
I'm talking about that knot in your stomach when someone is pushing you to sign, that feeling that you have no good options left. That's what this is all about. And you know what? The law actually has a name for that feeling. In fact, it has two.
And here they are, duress and undue influence. So the easiest way to get your head around them is like this. Duress, that's the holdup. It's an obvious, in-your-face threat that forces your hand. But undue influence, that's more like a con. It's subtle, a slow burn of manipulation that uses a relationship you trust against you. So one is all about the action, the threat itself, and the other is all about the relationship.
So let's dive into duress first. This is the one that always gets the big screen time in the movies, right? The overt threat. But in the real world, the concept is, frankly, a lot more complex and way more interesting than you might think.
What's so fascinating here is how the law's idea of a threat has evolved. I mean, it started centuries ago, basically recognizing obvious physical violence. But just look at that shift in the 1970s. The law finally caught up with reality. The reality that a threat to your business, to your financial survival, can be just as powerful, just as coercive as any physical threat. And that evolution brings us straight to the modern idea of economic duress. It's not about being afraid for your safety anymore, it's about being afraid for your livelihood. So, the million-dollar question is, where do you draw the line between just aggressive business tactics and illegal pressure? Well, the courts came up with a handy two-part test to figure that out. It all boils down to two pretty simple questions. First, did you actually have a real choice? Was your will genuinely overpowered? And second, was the pressure itself out of bounds, or was it just, the normal heat of doing business? Let's break down what each of those really means.
Okay, so what does coercion of the will actually mean? Let's put you in someone's shoes. Imagine you're this small company, CAFCO, from a really famous case. You've just landed a huge make-or-break contract with a big retailer. But then, literally at the last second, your only delivery company, Atlas, triples their price. And they tell you, pay up or your goods rot right here. If you don't pay, that huge contract is gone. Your business is toast. So I ask you, in that moment, do you really have another reasonable choice? The court said absolutely not. That is coercion.
But now for the tricky part. Look, business can be a contact sport. The law fully expects people to handle a bit of pressure. Driving a hard bargain is not illegal. So what's the magic ingredient that transforms normal, everyday pressure into something illegitimate? This comparison just lays it out perfectly. On the left, you've got a threat about the future, like, hey, we might not renew your contract. That's usually seen as just legitimate commercial pressure. But on the right, you have a threat to break an existing promise, to illegally stop deliveries that you're entitled to right now unless you pay more. Now, that often crosses the line. It's really the difference between negotiation and pure extortion. Okay, so let's shift gears. We're moving away from those outright threats and into something way more insidious, the abuse of trust. This is where we wade into the murky waters of undue influence, where the pressure isn't some external threat, it's coming from inside a relationship.
So undue influence basically comes in two flavors. You've got actual, which is where you can point to specific, provable moments of pressure. Think of a situation where one person is clearly bullying another into a financial decision and people saw it happen. But way more often, that pressure is invisible, and that's where presumed undue influence comes in. In these cases, the law looks at the type of relationship and basically says, hang on a second, the potential for exploitation here is so high, we're just going to start with the assumption that influence was a factor. And with this presumed influence idea, the relationship is absolutely everything. Some relationships, like doctor-patient or lawyer-client, they automatically raise a big red flag for the courts. For others, like spouses or partners, you first have to prove that one person really placed a super high degree of trust and confidence in the other to handle their money before that legal presumption even kicks in. But just having a trusting relationship isn't enough by itself to tear up a contract. I mean, people in trusting relationships do nice things for each other all the time. So the courts needed a smarter way to tell the difference between a genuine act of kindness and a deal that, well, just doesn't pass the smell test. And then along came this landmark case that pretty much changed the whole game. A super influential judge, Lord Nichols, he clarified the test. He said, look, a relationship of trust isn't enough. You need something more, something which calls for an explanation. And honestly, that simple phrase has become the absolute key to understanding how undue influence works today. So here's the bottom line. The modern test for this is really a two-punch combo. First, you've got to establish that relationship of trust. But second, and this is key, you have to show the deal itself is, well, just plain weird. It's so big, so lopsided, so bad for one person that it just begs the question, why on earth would they ever agree to that? And if you can prove both of those things, the whole game flips, the burden of proof shifts, and suddenly the person in the power position is the one who has to prove the deal was on the level.
Okay, so let's say you did it. You successfully made your case. The court agrees you are a victim of either duress or undue influence. So what actually happens to that contract you signed under all that pressure? The outcome here is incredibly powerful. The contract becomes voidable, and what that means is the person who is pressured gets to hold the kill switch. They can choose to let the whole thing stand if they want, or they can hit the rescind button, which is basically like a legal time machine that wipes the contract and everything done because of it completely out of existence.
So, let's just recap. At the end of the day, you have two powerful legal shields against unfair pressure. Duress is there to protect you from improper threats that overpower your free will. Undue influence protects you from that subtle manipulation that clouds your judgment. One is about the act, the other is about the relationship. They're different roads for sure, but they both lead to the exact same place, a way out of a bad deal.
The line between fair and unfair can still be a little blurry sometimes, but now you know exactly what to look for. So the next time you find yourself in a negotiation, just remember this. It's not just about what's written down in the contract. It's also about how you got there. And knowing that, well, that's a pretty powerful thing.